right, good afternoon, everyone. I'm going to call to order the meeting of the Sentencing Guidelines Commission for March 7th, 2024. I will ask Nate to go ahead and take it.
Roll call, Vice Chair Larkin.
Present.
Larkin present. Commissioner Crutchfield. Crutchfield absent. Commissioner Fraze.
Present.
Fraze present. Commissioner Knutson.
Present.
Knutson present. Commissioner Ladd.
Present.
Ladd present. Commissioner Middlebrook.
Present.
Middlebrook present. Commissioner Moore.
Present.
Moore present. Commissioner Morath.
Present.
Morath present. Commissioner Moran. Commissioner Moran absent. Commissioner Mueller. Commissioner Mueller absent. Commissioner Reeves.
Present.
Commissioner Reeves present. Commissioner Saxena. Commissioner Saxena. Saxena present. Roll call, Commissioner Crutchfield.
Present.
Crutchfield present. Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 11 members present, 2 members absent. Yes, we have Commissioners Moran and Mueller are absent at this time.
Okay, so with that, we do have a quorum. First item on the agenda is approval of the draft meeting agenda. I would entertain a motion to approve the agenda.
So moved.
Commissioner Larkin makes that motion. Commissioner Reeves seconds. Any discussion on the agenda? Hearing none, let's go ahead and vote on that.
To the Larkin motion to approve the meeting agenda. Larkin?
Yes.
Larkin, yes. Crutchfield?
Yes.
Crutchfield, yes. Fraze?
Yes.
Fraze, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Moran? Moran, absent. Mueller? Mueller, absent. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Third item on the agenda, approval of the draft meeting minutes from February 8th, 2024. You should have all had a chance to read those. They were sent out with the meeting materials a week ago. I would entertain a motion to approve the minutes. Commissioner Middlebrook moves, and we have a second. Commissioner Larkin seconds. Any discussion on the minutes? Hearing none, we'll go ahead and vote on that.
To the Middlebrook motion to approve the February 8th meeting minutes, Larkin?
Yes.
Larkin, yes. Crutchfield?
Yes.
Crutchfield, yes. Fraze?
Yes.
Fraze, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Moran? Moran, absent. Mueller? Mueller, absent. Reeves?
Abstain, not present.
Reeves abstains. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Okay. So fourth item on the agenda is comprehensive review public engagement planning update. So we have our consultants from MAD joining us again to go over a little bit more fleshed out plan for what they're going to be doing over the next couple of months. And I think I'm turning it over to Charlie.
Thanks, Chair Bishop. I'll actually hand it over to Shamsa to start us off, and then I'll take it
Gotcha.
over halfway through.
Sounds great. Thank you. Shamsa.
All right, are you all able to see my screen here?
Yes.
Okay. All right, thank you all. Good afternoon, members of the Minnesota Sentencing Guidelines Commission. My name is Shamsa, and I'm here today along with my colleague, Charlie, from Management Analysis and Development. And we are excited to provide you with an update on our preliminary plans for the comprehensive review engagement. As outlined in this memo, in previous commission meetings, the Minnesota Sentencing Guidelines has joined hands with MAD to conduct input sessions aimed at gathering insights from both practitioners and the public. The first round of sessions are occurring from March through June 2024. Our objectives encompass a thorough examination of the purpose and principles underlying the guidelines, the mechanics of sentencing departures, the assessment of defendants' criminal history, and the consideration of the severity of crimes being sentenced. MAD has crafted a plan encompassing the format, the structure, and timing of these engagement activities. We categorize input sessions into two segments, one tailored for individuals familiar with the existing sentencing guidelines, and the other for those without direct familiarity. So today we are here to provide you with an update of our preliminary plans. While we welcome any questions or feedback you may have, please note that no formal action or votes will be taken today. The session is solely intended for informational purposes. Let's dive into details of input sessions for individuals with direct familiarity with the sentencing guidelines. So the example audience would be prosecutors, defense attorneys, legal aid providers, probation officers, judges, and then correctional officers, law enforcement professionals, release reentry program staff, treatment and rehabilitative service providers, and others if they have direct familiarity with the sentencing guidelines. So the questions we'll be asking, the research topic questions we'll be asking are around what is working well with the current sentencing guidelines, what aspects of the sentencing guidelines are functioning effectively, what are the challenges with the current sentencing guidelines, what provisions are confusing or have different interpretations, what suggestions do people have for improvement. So in regards to the structured format, it's comprised of a blend of online and in-person meetings. Each meeting will accommodate small groups of up to 8 to 12 individuals, ensuring meaningful engagement. The sessions are designed to last about 90 minutes, allowing for comprehensive discussions. And the general process includes individual written reflection at the start of the meeting on several questions. After those questions are written, we will have a group discussion on each question. And after that session, we will follow up with online form to capture additional thoughts. So that's the first format for this group. The second format are written survey format. So the written survey format will be an online form survey alternative means of input. This will provide individuals who are not able to make it to the meetings to just submit their written format. We'll be asking the same key questions with the written survey format. And I'll turn it over to my colleague, Charlie, to describe more about the second category.
Thanks, Shamsa. So yeah, I'll talk about the formats we've designed for people without direct familiarity with the sentencing guidelines. So this would include many crime victims and their families, or individuals convicted of felony offenses and their families, as well as potentially some of those same people we mentioned for the other format if they didn't have direct familiarity. So that might mean corrections officers, law enforcement professionals. I want to note that across all of these, we want to give people some choice. So if they, let's say they are a law enforcement professional, but they do have a lot of familiarity with the guidelines, or they're a crime victim who does know a lot about the guidelines, they could choose the other format. We're just talking about who we imagine would be the typical audience. So for this, again, it would be people who have less familiarity, do not have the direct familiarity with the current guidelines. So the questions we're trying to answer from this group are a little bit broader about what characteristics or features would make sentencing more fair and just, or more clear and understandable. And then also, based on some conversation that we had with this body in the past, when is prison an appropriate punishment? When should we use other forms of punishment? Or when does the public or this broader group feel that prison is an appropriate punishment for an offense. So to get at those research questions or those topics, we've also designed a couple of different formats we're proposing here. So the first is called a story forum, where we're trying to capture people's specific lived experiences or stories that they wish to share. So this could be a mix of online or in-person opportunities for people to share their lived experiences that they or their family members have had in relation to criminal sentencing. So in that process, again, it could be an online video or written submission. We may also try to host small group sessions with partner organizations to capture some of those stories. And I'll note that we would be identifying, we would keep people's identities private from those forums. So MAD has a provision in the Data Practices Act that allows us to keep identifying information private. So we would do that in those story forums where we would only share de-identified stories and themes from the stories with the commission, but not the names of individual participants or information that could reasonably be used to identify them. And we'd be asking questions sort of based on those research questions about things, but we'd also be asking about their lived experiences, about what experiences they or their family have had with the criminal justice system that they want to share on their record. So that's the story forum format. If we scroll to the focus group format, so that's another format we would have with members of the public or practitioners who have less direct experience. So this would be for a range of different types of people who want to participate. So again, it could be practitioners who don't have as much direct familiarity. It could be members of the public. This is kind of the most flexible format we have, with a mix of online and in-person of, again, around 8 to 12 people, lasting 90 minutes. For this audience, we imagine starting off with a review of existing information to provide a kind of common baseline. So that would include a brief informational presentation on the current guidelines, and then also bringing in some of the de-identified stories that we had collected to share some of people's current experiences with the system. And then have a group discussion around those research questions where it would be a much more facilitated conversation, where we imagine the comments would build on one another based on what the participants are saying in conversation with one another. And similar to the listening session format that Shamsa described, we'd also be asking the group to summarize and synthesize what they are hearing across what others have shared. So what themes have emerged and where do they see tensions that we should explore further as a group. And then we'd also end with a follow-up survey where people could capture and write in additional comments that they didn't get to say in the meeting or that occurred to them afterwards. And that would also be an opportunity to ask some more structured questions if we wanted to do so to get the group's input. So that's a really brief introduction to some of the formats. I will pause here and see what feedback, questions, ideas the commission has. And then once we do that, we'll come back and talk about the timeline. But Chair Mitchell, I'll hand it back to you to kind of guide us in what questions your colleagues have.
Will do. Thank you, Shamsa and Charlie, for explaining the methodology you've come up with. So what questions or comments do we have from commission members? Commissioner Price.
I had an inquiry, I guess maybe it was sort of part of a general outreach to members of the commission. If I wish to suggest any academics for this outreach engagement, and I did suggest a number. I don't know where they would fall in this plan, or whether there is any interest in including them. I guess my point is just that I don't feel I should represent all of the academics who are interested in and know something about the guidelines and or about sentencing policy. So I'll just identify them as a group.
Thanks for that. And yeah, and please do, oh, sorry. Is it okay if I address that?
Yes, go ahead.
So yeah, please do continue to email us if you have specific recommendations for people or organizations that we should include in our outreach. In terms of academics, assuming that they are people who have familiarity with the current guidelines, then I think they could fit into some of those early formats that Shamsa was describing in terms of either the written format or a listening session. If you think that they would kind of need a different format or structure because of their unique background or information that they're sharing, welcome that feedback as well. But I think they could potentially fit into that first half of people who have familiarity and have kind of immediate feedback to give us. But Shamsa, does that resonate for you, or what would you say about academics and where they fit?
No, I also did receive communication from Commissioner Fraze regarding specific individuals that he recommended us to reach out to, and I do have that on my tracker sheet, so we will be reaching out to them and hopefully getting some input from them regarding this current sentencing guidelines in Minnesota.
Does that answer it, or do you have other?
Yeah, I guess the only further comment I would have is that since we are asking questions of a second group of people without direct familiarity with the sentencing guidelines, more generic questions like what would make sentencing more fair and just. I think there are probably academics and also various people in public policy, NGO type groups that came up in a previous meeting who would have thoughts about that, who may have thought quite a bit about why we punish and how we should punish. So I think that is a resource.
Great. So I think those organizations may have been captured in some of our earlier meetings. But if not, like I said, I think we continue to let them know, and then those organizations or individuals, I think, would probably have to let us know whether they have familiarity or not, so which bucket they fall into.
And I don't wish to exclude the Robina people who are, of course, academics and could be among the people to be reached out to, or it just didn't seem like their research part of this whole process was really the including what I'm talking about now.
Okay. All right. Other input or questions? I'm going to take silence as acceptance or agreement, general agreement with the plan that you've come up with. If there's no other feedback, then I think they can go full speed ahead.
Yeah, and then maybe, Chair Mitchell, if it works, I will share a little bit about the timeline just to remind people of kind of where we're headed next. So you've seen a version of this before, but just to kind of revisit it. So as Shamsa mentioned, we'll be doing these input sessions in the kind of the first main wave in March through June. And then over the summer in July and August, we will work to summarize the high-level findings, identify kind of what are the key concerns that we've heard from different groups, and confer with staff and with the U of M research team, and then come back to the commission more formally in September to present our findings and get your input and direction on what are the follow-up activities that would be most useful. So we've reserved some time in October through December to do, whether it's listening sessions or focus groups or surveys. We kind of want to be flexible at this point of what that would look like, but kind of fill in gaps from the first wave of engagement and do that follow-up before completing a final report in early 2025 that would kind of be the more formal document summarizing all of our findings alongside the process that we undertook together.
All right.
But I think that's it from our end.
Sounds good. Last call for comments or questions from the commission. Okay. Thank you so much, Charlie and Shamsa. You've done some really great work here. I'm very excited to see what you come up with.
Thanks, everyone.
All right, so then we will move on to item number 5, which is University of Minnesota Research Team update.
Good, I still have.
You might have your sound on, I'm not sure. I heard a little echo there.
I did hear that.
I muted you, you're good.
Good, good. Do you want my, I will start my video. Hopefully. There we go. Bad hair day. Good.
And Professor, you can, while you're setting that up, let me just advise everybody that I did email the presentation that Professor Yu is about to present
Oh, good.
to the commission members, and it should be posted online for members of the public before the meeting is over.
Very good. Begin the- Let's see, can all see a presentation and my volume is okay?
Yep, we're good to go.
Professor, I gotta be careful. Well, it is a very exciting time with the commission. I mean, I hear this comprehensive review underway, and we're thinking about how we can contribute to that. I'm also just have to say again how excited I am to work with commission staff who I don't want to reinvent the wheel on all of the capacities that folks have in the room. So just to note that in terms of our process, our research team meets with the staff and with Commissioner Mitchell and Director Reeds. I think we have something on the books tomorrow. So there's some feedback loops in here as well. Is that not correct?
I actually.
Okay. But I did want you to know that we're not going off into a room and huddling and then only seeing us, every month or two. I'll recap briefly some of our goals. At our last meeting, we gave kind of a menu of some research options that we could be looking at. And I thought the conversation was very lively, and we surfaced a lot of terrific issues that are researchable. Our team met and did some preliminary inquiries. And Aaron Sojourner, who's attending live today, also helped us think about, well, what would be easier to answer? What would be the harder thing to answer? It might take more time. And so we're coming back to you today for some help with prioritizing. And I want you all to think about, what would you be disappointed not to see some research on by the end of next year? So that might be a way to frame it. And I have my own list, but so I'll try to put a little more meat on the bone today with a few of the projects that we're talking about. And then see if we can get some sense for priority here as well. And some discussion and new ideas that enter in. So don't be afraid to raise something that wasn't raised, or if you hit something last time and I'm not capturing it on these slides, please bring that back up, or if I'm not doing it justice. We showed the slide on the research partnership before. What I wanted to kind of focus on was deliverables when I show this back up. So I highlighted policy briefs, presentations, longer reports. Those are all things we can do. And we realize in academia, you might not need a 100-page law review article with 250 footnotes in it to have actionable information. And so if there are 2 to 3 pagers, those we can assist with. And as I said, I very much would enjoy kind of collaborating with MSGC staff on those. And then there's presentations that we can give that might be a little bit of a deeper dive. And here we can take advantage not just of our original research, but also some things in the secondary literature that might be instructive from other states. And then we'll be doing longer reports. So I mentioned to the research team, we'll have to do an interim report for Arnold Ventures after the first year, or probably a little before the end of the first year. And we will do a final report, but we can also do longer form reports for the commission. But we need a sense of priority to do that. so that we can best use the available time. So I have, in discussing what was feasible or what was researchable, I had to go into the weeds a little bit, and you know, my Minnesota nemesis is buckthorn, so it's here the local is into the buckthorn, and that just means that there's some kind of wonky research points that might be good to discuss. First, that a lot of folks were raising big causal questions last time, which is exactly what you should be doing. You know, what is this a good thing to do, or what's the net benefit, or how, you know, things, everything from, you know, what are the causes of crime and recidivism to the trade-offs between probation and prison. We can address many of those. I mean, we're often on firmer ground when we describe what is happening than when we tell those causal stories. So in the farther we go into causality, often the more assumptions that we have to make about that. And so I highlighted a few principles here that when we do that, we are going to approach it with some humility and realize that the research team, we might be experts on some things, but certainly not others, and that we'll be clear that our knowledge is provisional and kind of share what we think we know, and then to be transparent about how we did it. And I think that's very important, and there are some necessary footnotes about how we measure this thing, because there are many interpretations, and if we're not clear about that, then any document we produce won't be reproducible for the commission, or you won't be able to track it down. And so that sometimes we can put that in an appendix, but I just give you a sense of that. I'm just fielding calls today where I said, gee, I wish I had included this in our report, because there's some confusion in Mississippi about how we calculated some numbers, and folks are asking me about that. Then some caveats about what might be missing, or what our analysis doesn't include that could affect our results. Now, this all sounds like we're peeling the onion back and we're not going to be able to conclude anything. That's not the case. Our goal is to provide useful, actionable information for the commission. But in doing so, we have to be honest and transparent. As I said, we discussed data access and availability last time. I think we're getting a firmer hand on that. I also wanted to just mention that some of the questions that folks were raising were more exploratory. That is, we've got to do a little bit of research that might be considered preliminary. We've got to go out and talk to some people. We've got to talk to some judges, perhaps, about how they do departures. We've got to go out and there isn't, you know, a well-developed research literature that might provide direct guides for action. And so that as long as we label it that way, that those kind of things we can certainly prioritize. And I know Julia is very interested in some of those types of questions. There's also things that can be more confirmatory, and that is where we have a well-established pattern of results in the literature, either in Minnesota or elsewhere. And what we're doing is simply testing, say, whether something that held from 1990 to 2015 might still hold to 2023, or whether the picture has changed. You know, that there we're on a little firmer ground, or whether a pattern that might be represented with other sentencing systems is also reproduced in Minnesota. As I say, I mean, I think we can do some, and I apologize for the digression into the weeds. Cut me off after 5 minutes if I ramble on. I also want to introduce, you saw our team last time. It's a terrific group, and I just wanted to draw attention to a couple of the consultants we have on the team. Ryan Larson is a criminologist at Hamline University, who has particular expertise in spatial analysis, as well as a range of techniques, and has worked with Aaron and I on some other projects. And then Robert Stewart, a professor at the University of Maryland. Many of you may be familiar with Rob, lived in the Twin Cities for many years. and is very good at some of the wonkier details regarding Minnesota sentencing, and it's raised a couple of the questions you'll see on the slides coming later. So the team is a little bigger, and those folks will be attending many of our meetings as well. Now, I'll put things into a few buckets, and just to give you a sense of, the first bucket is the biggest, and that is the impact of specific sentencing changes to law or policy. And here, one of the things we're looking for, what are the changes or practices that you're most interested in examining? And we can kind of train our vision on some of those. Then there's the public safety question emerged quite a bit, and how we might go about approaching the commission's role in ensuring public safety. We also heard a lot about probation in our last meeting, and I'll say less about that, but try to at least stimulate some thoughts and discussions. And then a few big open questions that some of them that are researchable if there's interest in the short term, and then some of them that might require some more infrastructure to be built in terms of data matching and working across systems. So what kind of sentencing changes, policy changes might be of interest? Well, we've had a number. And the reason I'm kind of focusing on this is that where we have change, we often have a greater ability to detect impact than if we're just observing something that's more steady state. So things like a probation cap that was recently implemented, the grids for drugs and sex offenses, felony DWI, et cetera. I'm interested in extended juvenile jurisdiction and how that has affected youth. There's a range of other, perhaps smaller questions, or I shouldn't say smaller, but I should say more fine-grained, detailed things like the custody status decay factor. That we don't want to we don't want to necessarily go into the weeds on absolutely everything, but we want to know what you're thinking of, and again, what is actionable and useful information for you to have. Now, what kind of outcomes will we be looking at for these if we think of that as the treatment, those changes, what are the outcomes that we might expect? Well, certainly disposition and duration of sentencing, overall Minnesota correctional populations, criminal history scores, departure rates, disparities across groups or regions, all of these sorts of things we can examine. But it would be helpful to hear from this group if there are particular priority items that we should be examining. And then we'll go back and figure out, well, okay, how clean is that treatment, and how can we really examine it? Then I'll say more about public safety in the next slide. So for example, if there's some concern that judges were more likely to use prison after implementation of the probation cap, that is a researchable question that we should now be able to look at. Or for example, and this is, I know that the commission and others have examined some of these questions, but whether felony DWI, how has that impacted Minnesota correctional populations since 2002? This is just to tee up a few examples of the sorts of things that we can work with in combination or in collaboration with the commission.
You can hang on 1 sec. We have one question, Commissioner Larkin.
Oh, yes.
Oh, and I wasn't sure if I was jumping the gun.
No.
What issue do you foresee studying with regard to extended juvenile jurisdiction?
For me, it's a broad bucket, but has the treatment of youth on EJJ have they had more or less successful outcomes because they've been on EJJ? And so that is a, I've looked to some extent at the proliferation of blended sentencing across the country, and there was a big wave in the 90s, but I know it doesn't seem to be uniformly applied. And so we might be able to get some purchase on what has happened since CJJ. But frankly, my thoughts on that are fairly ill-formed, Commissioner Larkin, but I do think that occurred to me as I was going down this list. And Commissioner Reeves, probably, we talked about EJJ when you were at the university, that this is we know there's a fairly high failure rate. And so so that's the reason for its appearance. But as I say, it's not necessarily something that we have terrific data on. But that was one that I said, oh, my curiosity is piqued.
Go ahead.
Yes.
As somebody who was around when EJJ came to be and
Yes.
advocated for it as a public defender,
Mhm.
we saw it as a way to avoid sending kids to prison who are otherwise well on their way. I appreciate the interest.
Mhm.
I guess my initial reaction is like, that is such a huge topic. And I feel like maybe it's beyond comprehensive review of the guidelines, because the guidelines themselves don't really distinguish. I mean, once you're EJJ, you get your sentence as if. So I wonder if that is broader than sort of reviewing the existing guidelines. I think it's important
Right.
and it should be done. I'm just wondering if the resources are there to do it appropriately if we do it as part of this comprehensive review. Just a reaction.
And those are exactly the types of reactions that we're hoping to surface here. So that's very helpful to know. And and there are some data issues, especially regarding people under 18, et cetera. So, but let me continue to bucket number 2 to give some sense for how we're thinking about public safety and our conversation earlier. And here I can kind of tier things about by degree of difficulty. That first, the question is kind of how to quantify. Well, the easy way to quantify is reconviction and reincarceration. We have certainly plenty of data there. And we can do that within MSGC data, tracking individuals over time, adjusting for the time that they would be that they would not be incarcerated. And we can look at things like the role of departures in sentencing, in reconviction and reincarceration. Medium term, and that means things that might require a little more data or certainly analysis and planning, is to understand the patterns of trajectories. And I heard some interest there regarding people like, are they kind of bouncing around with low-level offenses and eventually go to prison and then desist from serious crime? Or is it more of a trajectory in which they are committing serious crimes and being reincarcerated for them? The recidivism itself is often, as you all know, a very crude indicator of just, did someone have a reoffense, which might be measured by arrest. And we know we can go significantly beyond that. We can look at the type of reoffense, we can look at the timing, et cetera. But we can certainly identify some patterns or trajectories. The more typical way to do this sort of analysis is to start with a released cohort from everybody who's left DOC supervision in a particular year and follow them out. But I think there are some interesting things we can do with the guidelines data, and perhaps is supplemented with additional information from the State Court Administrator's Office. So this is something that Ryan Larson, I mentioned, we've been working to do some of this work. And he has some expertise and knows where some of the bigger challenges are in terms of working with those data. Longer term, we can also, I think it's important to look beyond recidivism, beyond, say, new criminal behavior, to what sort of successful outcomes sentencing that might be associated with sentencing. And that is employment, education, and training, which Erin has particular expertise in, civic participation, health and well-being. All of these are potential knock-on effects and are amenable to, there are some ways to match data across state systems. But this would take, you know, a fair amount of work to do to do justice to some of these things. But I would say that is where a lot of the action is nationally in terms of research. Is look, people know that the recidivism is not the best way to measure like program success, often because it is a kind of a crude indicator and it's not well measured. But it is the easiest thing we can do. And so we will likely continue to do it, but we need to look beyond that. And I think there are some potentials, there are some longer term potentials to examine those questions as well. And I have a link to the Limits of Recidivism National Academy's report a couple of years ago that I worked on that has, a lot of ideas along that way. It's not to say, oh, I think we can, do all this in the next year and a half. It's only to say that a discussion of public safety would likely, we need to at least acknowledge that these are also important pieces of public safety. And I did want to just point out and make a link perhaps to your community comprehensive review in that how is the community defining public safety? How are practitioners defining public safety? And even the clients within the system, how are they considering it? Yes.
Commissioner Crutchfield.
Commissioner.
Thank you, Madam Chair. This is an odd question maybe, but has any research been done as to minimums and maximums? A minimum incarceration, anything below that has absolutely no effect at all, and anything beyond a certain amount of months, there's no more or less effect, either positive or negative. Do you understand my question?
I do. I believe so, Commissioner. I have seen research on, say, in a labor market space, on the scarring effects of incarceration and whether 2 weeks is sometimes a threshold for some of that research because one often loses a job. And there's some. But there is kind of another way to think of it as a dose response, and so we have the tools to examine that. And I think we have talked about, it's not like what is the optimal length necessarily. We can answer that definitively, but we can look at what are some of the effects. And I think that's, the issue is there excess punishment in the system or insufficient punishment in the system? And I know that is an important question. And if, that's one that we may not be able to nail down with complete certainty, but it is researchable and it is the sort of thing, because we have data on that, on those indicators, we can get a sense.
Thank you.
Commissioner Larkin.
Yes.
And I don't know if this is a question for you as opposed to Nate, but in thinking about this meeting today and having talked with some of my colleagues who are district court judges, the one thing they say, especially some folks in Hennepin County who are struggling with things, there are a lot of people who don't need to go to prison, period. What they're struggling with is how do they identify who needs to go to prison for significant time. So one thing
Right.
I'm wondering is, do we know on any given day, from the DOC, here's how many beds they have, here's how many are filled, and who is filling those beds? In other words, we get the sentencing data that says, okay, here's how many people have been sentenced for this type of crime. Do we have a way to know who's incarcerated and why. In other words, you know, this many people are incarcerated for this type of crime. This many people are here not because they have a new offense, but rather straight revocation, no new offense versus revocation with a new offense. So serious offense, not, I mean, I feel like that's one thing I don't know after all the years here. And I feel like that's context for what we're talking about, because if we're trying to figure out how much time is really necessary, are we giving people too much time, too little time? And I don't know that what I'm asking for connects with that, but I feel that they must be related in terms of figuring out who's getting to prison, who shouldn't be there, why is that happening? As opposed to, no, we all probably agree that this category of folks needs to be in prison for a long time just to incapacitate them.
Yes, if I may, I mean, one way to think of this is as stock and flow of people into prison. That we have the people who are being sentenced. They're often less serious. The folks, or they've committed less serious offenses on average that appear in our Sentencing Commission guidelines data than those who are currently incarcerated. In part because the people who are currently incarcerated, the people who are there for a longer time, make up a larger share. And so you'll see a higher representation of homicide, criminal sexual conduct, and you'll see, so those tend to pile up in prisons. So it is the case that in Minnesota prisons, there is a high percentage are in for more serious violent crimes, but the churn is often lower level, and more often is, you know, to use that language of people who may not need to be incarcerated, and to the jails, it's heightened, you know, as well. The churn is much greater.
Let me just add to that, excellent question. And
Yes.
yeah, I do believe that we could probably get Grant Dewey to do a presentation on the sort of what I had those, I wrote those things down before you said them on the stock versus flow, right? Like what ends up in, who are the people that are churning, what types of offenses do we have? And I've seen it a couple of times since I've started working at DOC, so it's there. We can definitely, I'll ask him about coming to do a presentation on that. I think that's really good information to have. And then, but I have a question back for you.
Yes.
Which would relate to that, which is when I think about these questions, the sentencing questions before, how do we deal with the pandemic? Because we know that the backlog from the courts actually makes all of these numbers look a little wonky right now.
That's right.
It's not the cases aren't flowing in the way they normally would have. So I think more serious cases are getting dealt with faster than less serious cases. So some of that stuff is a little off. And I'm curious if you talked at all about how you might deal with that.
Yeah, I would say there is no, to my knowledge, no research consensus, and a lot of what we're doing is ad hoc. But we know lockdown dates, for example, and so often we will include an adjustment factor for, you know, when during the lockdown. In some cases, you know, the other social events like the racial justice uprising after George Floyd was killed, those are we can include an adjustment term for, say, the 3-month period following in some analysis. But the pandemic, you know, we know the dates that courts were open or closed to some extent, but those boundaries are a little fuzzy, as you know. So I would say this is where it takes a little bit of humility to know. One of the things that I'd say is that there were a lot of changes during the pandemic, and I'm not sure it was all about the lockdown, for example, if we include a term, right? But we can certainly add that adjustment factor, and then we can look at, well, what did it look like before we adjusted and versus after adjusted? And if we get a consistent answer, that gives us greater confidence that.
Yeah, I was gonna say that too. It feels like it would be difficult to know how what you're seeing in the more recent data is a reflection of a change in practice that has continued versus a temporary change in practice that happened because of COVID. You know what I mean? Like some people rethought how they used these resources. And so I think there are lasting changes that came out of COVID.
That's correct. And I think certainly in probation and parole practice, we learned, a great deal during this period, so there are many other kinds of adjustments, and this is where, the smarter economist in the room, Erin, maybe, is used to seasonality, measuring seasonality, measuring smooth trends, isolating, periods where we think would be more or less effective. I mean, right now, I think we're not like back to normal necessarily. We may be, working through a backlog. And when you're working through a backlog, that may look a little different than, the pre would or the baseline. So I think that is going to be a continuing discussion, I think, a point of emphasis and debate.
Yeah, in terms of the pandemic, I mean, we should be able to get numbers from the judicial branch regarding the backlog. In my sense, just on our court, is we're pretty well through it. We're seeing our numbers back up, and it's like the cases are getting to us. And just anecdotally, my sense during COVID was they had such a backlog, they needed to get rid of it, and they were cutting incredible deals to settle cases. So but that probably doesn't, give us an accurate picture of how things would otherwise look now, because a lot of people, I'm told, got great deals. But in terms of, is there still a backlog, or are we past it to the extent that's relevant? I think the court has those numbers, right?
And the goal is that the backlog is going to be decreed to be over by July. I think, and many judicial districts have already done what they needed to do to get out from under the backlog. There are a few districts that technically are still behind, but I think Judge Larkin is correct. I think we are absolutely on the far back end of the backlog. But her point is valid. I mean, is what happened during the period of 2020 to probably 2023, might be a bit of an aberration to some degree regarding some of the dispositions.
I think that's an excellent point. And one of the things that we'll, we often, in all of our analyses, we do a lot of tests for robustness and sensitivity to different assumptions in different periods. I mean, everything from assuming that, just like the astronauts would lose communication, when they went around the moon or something, we can assume that, that is a complete unknown and block out a period for some purposes, or we can try to model these processes. But I think that's where having some textured knowledge of what's happening in particular courts. We also have variation around the state, as we all know, so we can take advantage of some of that as well. So all excellent questions. So I want to get to our open things up, and so let me be a little bit briefer in talking about probation. One is that short term, we can certainly provide some descriptive profile over time about the fate of people on probation, or the percent returning to prison, et cetera, and how that affects correctional populations. And the Guidelines Commission staff has directed us to some resources on that already, and some very good analysis. We can look at the distribution of people on probation before and after the policy changes. Medium term, we were very taken with this logic of serving time on the installment plan and what that looks like. And that's a harder process to model, but it is certainly something that we can try to understand within person what those trajectories look like. And then some questions have arisen around the length of probation terms and their impact on collateral sanctions. and the felony misdemeanor divide, which can become a little messier in practice. The longer term, we can look at probation and multi-system involvement, and as well as like county-specific probation conditions and changes in county-specific probation conditions, how that may affect outcomes, if that is an interest. The diagram, it just references a study of reentry just to show some of the complexity, though, where I track people who left Minnesota institutions from 18 to 25, leaving juvenile justice, prison, mental health, chemical health care, foster care, National Guard, and jail. And you can see that there are some pathways that are really well worn, that people can move from prison. People move back and forth from prison to jail. They move back and forth from chemical health to jail. In fact, a lot of people end up in jail from all of these different groups. And so I mention this only to say we don't currently have a data system that would allow us to track these sorts of flows. But that's the sort of thing that I've thought about would be possible to build if all of the permissions could be granted, et cetera. But I mention it as only an example, and this would be considered in the exploratory bucket right here. Probably a little beyond the commission's current interest, but I mention it that we know that the pathways are complicated. So some of the big open questions, I mentioned probation and its efficacy. Why are there so many departures? That's something that seemed to surface last time. There's ways to approach that qualitatively as well as quantitatively to understand why we have a density of a high degree of departures for particular offense categories. How changes in record keeping may have affected things like criminal history scores. Those are problems we are eager to tackle. Things that are more difficult are examining multi-system involvement, substance use, et cetera. Those are likely to be difficult. Use of jails and alternatives, the data are not quite as clear. We have good contextual data on what the jail populations look like in a county in a given period, or decent data. But we don't necessarily know all of the individual pathways, and particularly things like pretrial detention. Collateral consequences, I'll just mention one thing that complicates efforts to compute these. Are stays of adjudication are different than stays of imposition, than stays of execution, which I think the commission is familiar with. But whether one is actually affected by, or whether one can vote, or whether one can practice in particular occupations, really depends crucially on those sorts of distinctions. So those are researchable questions, but those get you way into the weeds rather quickly. And then some of the big picture things like what is working and not working that may be beyond the control of the Guidelines Commission. So I do want to tee up what are some of the, if we went around the room or if people want to raise things, what are the must-do priority items that we should at least be taking a look at and discussing? And we can come back to you and say, well, we can't give you much great evidence on this, but we want to hear which items we should prioritize. What are some things that haven't been mentioned or emphasized in our previous discussions, or things that you might have said that we did not fully capture because we went off down our researcher trail too quickly? And then some of the timelines. If we are going to schedule out our time, and Julia is the chief organizer on our project here, that I know that she would like us to be thinking about, okay, when should we be talking about delivering some information to you? What do you need in late summer, early fall, for example, or would be helpful to have? What are some things that that might have a bit longer of a ramp up? So then beyond that, it's these bigger picture things that might tie into your comprehensive review is what are the longer term priorities where you want to build infrastructure so that you can answer some of these questions more definitively, more authoritatively, if not more definitively. And again, the spirit here is one of collaboration, so that once we're all talking the same language, it becomes much easier in time. We build some trust. And as I said, we may discover that the Guidelines Commission staff has good answers to many of these questions already. So with that, must-dos.
Open it up for comments from the commission.
Madam Chair,
Commissioner Knudsen.
one thing that we hear in the public debate constantly is, Minnesota has such a low rate of incarceration among U.S. states. Well, what does that mean? Because we've got so many local jails that are taking the place of some of the incarceration, where many of the states have more the state prison system that they rely on for the loss of liberty. So if we get through that, we will look at that, and then the issue is, well, my goodness, Minnesota is just out of bounds with the number of people that we have on probation.
Yes.
And so, what do we measure? That are we? What's more effective by case type and by severity of that case type? The incarceration, the loss of liberty, or the rehabilitative services that people should supposedly be getting on probation? You can't say we don't send enough. We don't incarcerate enough people, and well, I'm just trying to figure out what is the magic ratio, if there is one. Where are we really in comparison to other states, and what's more effective approach to these different case types, either probation and rehabilitative services, or at some point, and what is that point? You know what? You need separation, and your liberty is going to be taken away. And so, how do we get at that and have that discussion? And get some data that would put some meat on the bones there.
Professor Eugen.
Yeah, I could speak briefly. I mean, you didn't come back with the easy question first. I mean, that's good. But I do think putting Minnesota in context, there are some areas where we rank low, and Kevin is certainly an expert on these. There are some where we're much higher. For example, this is outside the purview perhaps, but Minnesota leads in civil commitment for people for sex crimes. That we have a much higher rate than every other state on that indicator. And so there are groups that some of you may have seen the whole pie pictures of where people are in the United States, how many on probation, how many on parole, how many in juvenile facilities, et cetera. That does provide a more comprehensive view of Minnesota's relative position, and we can do a little analysis on that if that would be helpful to show, that Minnesota has a distinctive set of punishment that if you look at it, Commissioner Knudsen is absolutely right. If you look at one metric, you really do get perhaps a misleading picture. If you just, it's certainly not something you can say was lenient or punitive. If you just look at say the raw incarceration rate, but But I think that might be useful in providing some context. I mean, I'd be happy to work on assembling. Again, that's fairly descriptive data. There's some pieces of it that are tricky to track down, but I think it's certainly within our capacity. The broader question about the efficacy of probation versus prison, that's a harder research question to answer, but that is the sort of thing that the public safety bucket is designed to get at, you know, and so so that is what is the impact of different types of sentences on reconviction and reincarceration. So that as well as some of that the dose response issues or the amount of time, those are also researchable. Again, we'll have to do this with caveats, but I think those we can certainly try to at least give a report on those types of questions. I've talked too long.
Yeah, I've got a question
thank
from
you.
Commissioner. Oh, okay. Got a question from Commissioner Ladd and then Commissioner Larkin. Commissioner Ladd.
Thank you, Madam Chair. And I'm just going to kind of try to piggyback on what Judge Knudsen just said, maybe as an aside. I think one of the things I'm interested in, and I don't mean to repeat myself from the last meeting, is we talk a lot about departure rates as an indicator of how we have certain classes of offenses weighted and the sentences attached to those things, and the departure rates are somehow some cue for us to know that perhaps we should look at that and have different sentences and consequences attached to that. But I think if we don't understand sort of how people get to prison in the first place, I don't know that that's helpful data. So for example, if someone is sentenced at their sentencing hearing and they go to the Department of Corrections to serve their sentence, that's vastly different than somebody who gets a departure and gets several revocations and then also then ends up back in prison as a result of a probation track that failed for whatever reason, and then they end up in prison. So just to say that we know how many people are in prison and what kinds of crimes they've committed, I don't think that's telling very much to us about how they got there and where our resources in our system are best being used or being expended. And the departure rates aren't particularly helpful if those people end up back in prison as well, because that also tells us from public safety perspective and also from other things related to community-based services, that wasn't successful. And I think, when you have these sentences where people have a lot of pretrial jail credit, and we know what those are because on their sentencing order, their jail credit is pronounced. And if someone has a felony domestic assault and it's a commit to prison for 24 months, but they've got 200 days of jail credit on a pretrial basis on that domestic assault, versus somebody who maybe doesn't have a lot of jail credit and that person then gets a departure, we're comparing that kind of felony domestic assault to the person who had lots of trouble on a pretrial basis. So I worry that we're going to make some decisions about how we view types of offenses and whether or not they're being, the severity of how the punishment is attached to them as being accurate if we don't really understand how they get to prison in the first place. And I do think that's important to know. And again, I know there's probably not easy answers for that, but I think we need to know, because a lot of people don't go to prison right out of the gate at sentencing.
We're asking all the easy questions, right?
Yeah, but those are very important. I mean, I would just say that I'm learning, and I'm saying, well, we can indeed adjust for pretrial jail credit as a factor in any sort of analysis here, or you can name and tell us about these processes so that we can do a much better analysis.
Okay, Commissioner Larkin and then Commissioner Reeves.
I don't even know how to frame it. These are just thoughts I have,
Yeah.
Piggybacking on the last two observations. I would be curious to know if other states just impose a consequence for a low-level felony without probation. Because it seems to me, we put everybody on probation in Minnesota. And even if you say, well, it's, unstructured this or that, it's still hoops to jump through. And are those hoops tripping people up? And if we're putting everyone who pleads guilty to a felony or a misdemeanor or a gross misdemeanor on probation, in the sense that there's an open file and somebody has to track it, we'd be better served to focus on DWI offenders, domestic assault, like those offenses where there is sort of an obvious treatment component. And I sometimes will see sentences from out of state will be like, well, this was a simple robbery. He got 90 days. He's not on probation. Is that the worst thing? And I suppose here the problem becomes, well, if you do 90 days, then it's not a felony on your record. So maybe that leads us to ask, well, should we kind of change how we calculate the sentence for inclusion in criminal history score? I mean, I don't know. I just feel like there are probably cases, even at the felony level, where we could simply say, yeah, you need a consequence because as a society, we expect you to have a consequence and you really don't have any treatment needs or problems that we can effectively solve. So can we just give some people some consequences and put the resources elsewhere? And I don't know that that's a viable option, but I see outstate sentences that indicate people aren't going to prison for offenses for which we would have a prison sentence. They're just taking their consequence and they're done.
Yeah, I would weigh in briefly. That is a key question, and there are particular offense categories, as you're naming, that we know that people who may enter the system and one gets probation and one gets a shorter prison term, and which is better to be 5 years of probation or 9 months incarcerated, is an open question. I mean, those are things we can examine. I would say that in the literature, a lot of what people talk about net widening, that is, if you have a less severe sanction, the threshold for applying it becomes lower. And so some states that use very little probation or community supervision, it may not be that they're going to prison. It may be that they're not getting that consequence. So but those are, I think taking advantage of those areas, the more gray area offense categories, we can have a sense for how people do in each of those.
I was just going to say, because I think that ties back to my earlier concern about, okay, do we have a small group of folks in prison who have no business being in prison? And did they just get there because they couldn't jump through the hoops?
Right.
Why even set up the hoops? Why not just say, okay, you did your 90 days, you're done, and not have, and I think the public would agree if you said, well, this person, wrote a felony amount of bad checks. Do you think they should ever be in prison? Probably the answer is no. They should pay restitution and have some sort of consequence or community service, but it is a felony level offense, so we seem to put them on that track. And I don't know if that's something that we can tackle with my bigger goal of put the people that need to be in prison and be separated there and find a more effective way to deal with the other folks.
Yeah, I think that there are some promising ways to approach that. And I won't say more today in the interest of time, but I think that is it's a key fundamental question, I think from the perspective of the person on probation, for example, that not only is it the supervision, but it is compliance with probation conditions, which may be experienced as onerous or potentially disrupting other activities. So I think it's an important question to examine.
Commissioner Reese.
Thank you, Madam Chair. I'm thinking a lot about this area. A couple of things. When we're talking about revocations, I think Commissioner Land, I believe, makes a good point in terms of what that looks like. I don't know if you guys can compile or what's already being done, because the number of revocations that someone has, because I think we use different language. Me, I use execution as opposed to revocation if you're going to prison. And I know that's been a contention in Hennepin County because people use different verbiage. revocation to me is 10 days, 20 days, whatever it is. And some people think it's revocation of the entire sentence. So the terminology matters. But in this context, I'm thinking of revocation in terms of some time in jail, whether it's the whole sentence or the part of the sentence or not. How many times did they get revoked prior to being executed would be interesting to me, because if we're talking about people that are on probation and what they're going to prison for, that matters. Because in the community, there's this conversation about we're sending people to prison because they missed the bus. I mean, I don't even know, that makes no sense to me. It really doesn't. I don't even think a supervisor would allow it, but there's communication in the community that we do that. There's laws that have been passed with that verbiage as a reason why these laws should be passed, in particular last session. So I'm really curious about that, if that data can be compiled. Because for me, as a high-risk agent, if someone revokes several times, it's going to take a lot for me to try to send that person to prison because they couldn't get complete treatment or things like that. You do all you can in the community to try to make that work. So if they go to prison as a result of being unamenable to probation, what does that look like? How long did that take? Because that's more interesting to me than just saying they revoked and going to prison. How much work was done by the agent in the community to make that happen? I'm also thinking about dosage, the dosage model that we have currently in supervision, and how that affects when people are being revoked or execution of sentence. What does that look like? Because those things that are happening in the community as to reasons why people are going back into custody. That would be of interest to me. And then the autonomy of the agents, I think, is really, really important here in terms of when they're actually sending people and how they're supervising clients, how that gets into going into the facility, whether it's the workhouse in jurisdictions or whether it's the prison. So I'm thinking a lot and trying to put it all together. But in terms of PSIs, we have clients that don't get a PSI, so they go right from court right to supervision. And I'm thinking about what Commissioner Watkins said in terms of what does it look like for treatment options? Are they getting treatment options? Is it an appropriate condition? When I'm seeing clients that never get, for example, a chemical dependency evaluation order, but they need one, so they get to go back to court because there was no a sentence that was given on a particular offense didn't see was warranted. So all these things matter in terms of the end result of revocation or execution of the sentence, and so or digging deep into probation. I would like to see some more research on that, because that narrative in the community is challenging, especially when we know people that are not actually doing that and supervisors aren't approving it. But there's also a misconception between probation and parole, which is evidently clear when we're having the conversation. Thank you.
Sure.
Thank you.
Do you want to respond to that first?
Yes, I mean, I would say here I have to be somewhat cautious with the limitations on our data, that sometimes we only have crude approximations. And we know that, those interactions with the officer, some may be recorded, others may not. I mean, I think the one of the trade-offs is we could do more detailed kind of case studies of how people travel through the systems that would be more textured, or we could do broader overviews that would only have kind of relatively crude measures, but would help us sequence things. So I think the research team, and I'm not equipped to answer, about feasibility here, but I just say, like, my reading of the data is that we don't quite have the capacity to do a quantitative analysis of each of those considerations. But that's something we could build toward. It's just, is that information ever recorded anywhere? And how well, how complete are those data? But as I say, I think there's certainly ways to approach that would help us understand.
I would say it's much more better recorded now because we're all in the same system across the state.
Yeah.
And the thing that we put in place when we chrono what happened in court, I think it's much easier now to get the data than it was previously, based on what everyone's asking for.
Excellent.
Commissioner Crutchfield?
Thank you, Madam Chair. All I was going to say is Commissioner Reeves is from Hennepin County.
Right.
And she's talking about what's happening in Hennepin County, and it's complicated enough. But then you talk about what's happening in Lake of the Woods County, or down in Mower County, or suburban versus urban versus greater Minnesota. It's very complicated very quickly.
Yeah, and that's correct. And I'll just respond briefly. I mean, I know that Hennepin County recently, my understanding is that they they no longer do routine drug testing across the board, that they do that for targeted populations. Well, that gives us some ability to examine, well, what is the effect of those kind of policies if we have a long enough time window, or to compare if we have other counties that we could compare against. So so in some ways that's an analytic problem in characterizing the whole state, but it also gives us some variation in terms of understanding, well, okay, how does this affect populations or revocation rates or other things like that.
Other feedback, comments? Then I get to go. This has actually been a really good discussion, because what I bring it back to is one of the first slides that you had talked about actionable for MSGC. Yes. And so I think about what is actionable for us. And, you know, the very first guidelines were created by taking all of the historical sentencing data that happened, you know, running that to sort of see where sentencing fell, figuring out like averages, like on average this was prison, on average this wasn't, and then norming that, like the commission taking the time to then norm that process and say, okay, well, there's this wide range of possibilities on this offense, but you know, a typical offense is this, so the typical sentence should be this, you know. So that's how the guidelines were, you know, essentially created. And we're kind of at this point again where I think we need to figure out if they're working, right? Like if I mean, and of course, and I know I'm all over the place, but that's okay. The slide that you had that showed even our guidelines changes really brought home to me, like I wasn't even really keyed into, like we've had significant policy changes ourselves with new grids and all of that stuff without doing that again, without doing that process. So, you know, to me, this question of, okay, we have a set of rules that say prison or probation, but this question that keeps getting raised about, well, do people end up in prison anyway when they're on probation? Right. I think that's a really good question. It's like, how do people get there? What is the path that somebody is experiencing, and sort of what does that mean for what the right place to land is? I think that might really be a very important question to hone in on, and actionable by us too, to try to take that information and see what that means for the policy and whether it's working or not. I don't know that I'm like fully effectively articulating that, but I've heard a lot, like this emphasis on public safety, I think today has been, I've heard a lot of emphasis on the stuff that would fall into the public safety bucket. I do think that's important. So I'm sort of leaning to that camp, but I would also say that I think if, you know, you asked the question, if we get a year and a half down the road and we haven't done this, right, what would I regret? It's the high departure cases. You know, we do have this handful of cases that are just, nobody's following the guidelines in any way, shape, or form. And some of that's intertwined with mandatory minimums too. So it's not just our policy, but also legislative policy. And I think if we don't do a deep dive on those, that we will have missed the boat in some respect. And we should really get in there. But I also think the answer may not be in the data. It may be in really getting out there to figure out what these cases look like, what considerations judges, prosecutors, and defense attorneys have when they're faced with these cases, and why the plea agreement might end up at a departure. Because I think that will tell us something about what either we need to do to change the policy, or what we need to recommend to the legislature to change the policy on that, if it's a mandatory minimum that's getting in the way, or is exacerbating the way that people are seeing those cases. So those are the kind of two things that seem to be rising to the top for me. And I don't know if I was articulate at all, but on that first one, but.
Yeah, I think the second on departure, I think that is something that we can certainly do a deep dive and try to kind of advance knowledge on that and surface information. On the first one about, say, is that more about the relative efficacy of prison and probation for like folks, or is it because I heard are the guidelines working? And in a sense, I mean, there's a comparative question there about, we always have to ask relative to what. And so, when we were talking about excess punishment in this system, well, I can tell you states that have more of that than Minnesota does. And so, relatively, we probably have less that I don't want to badmouth any other states, but on the other hand, relative to our standards and our ideals and what makes the most sense for the state, yes, there's likely ways to go. So so I think these are maybe to put it in two separate things. I think there's practical things we can do to dive into the departure issue and produce some information that could be useful for the commission. And I also think there's a big research project that we can also do on the efficacy of prison probation, et cetera, that we'll have to go back and talk about and report back on. But I do think those are researchable. One is just a little more tractable, seems a little more tractable today. And then the other we might have to iterate a little bit where we say, well, what about this type of analysis, and come back.
And the two are tied on the second one. You just talked about the efficacy. It is tied to the guidelines in that we set the disposition line. So we determine whether it's prison or probation based on that disposition line. Now the courts can deviate from that, but we set the baseline for that, right? So
Right.
Then if we're setting that baseline in a place that doesn't make sense, based on the experience that's actually happening in the field, then we should know that. And we should, figure out what that means for how that policy is put into the structure of our guidelines. Does that make sense?
Exactly. Yeah, and I think that's to me, it's very sequential. Is that it's a path? There's a path to disposition, and then there's a path to severity or length, duration after that. Yeah. And so people get on either one of those tracks, and then we can examine the impact, and then we can adjust for differential selection into each of those tracks to some extent. So, yeah, and we don't want to go into the weeds, I know, today on this, but I do think, just to say it's a big, hairy, audacious goal, but I think it is. I can see ways to at least get some vantage on it, and I'm also mindful of not writing checks that the whole team is going to have to cash or pay, today. But I do think we can make progress there, and if we think of it in terms of advancing knowledge, I know we can advance knowledge on some of these questions. But I don't know, exactly how far we can get to the destination.
Got it. Commissioner Larkin, did you have your hand up too? No. Oh, okay, Commissioner Larkin.
Just piggybacking again, I think we have to be very careful though when we look at departure rates to recognize that many departures are the results of plea bargaining.
Right.
So I don't think we can simply say, well, there's this category of offense, everybody's getting a departure, that means we have it ranked improperly. I think we have to say, well, of the people who got a departure, was that solely because of plea bargaining? Having nothing to do with whether or not the crime itself warrants incarceration.
That's correct. Exactly. You don't need me to tell you that's correct. Excuse me, Commissioner.
Can we measure that though?
That's why I was saying that I think that's where they talked about doing some qualitative work.
Okay.
Yeah.
And I think that's where interviewing judges, prosecutors, defense attorneys gets them that additional insight into why is this whole category of cases getting high departure rates? Like what are the scenarios, situations that you're running into that are causing the plea agreement.
Exactly, yeah, and there's going to be a few black boxes here in terms of the quantitative data that we can access. I would say those kind of interviews can be really informative, though. You know, I was interested in monetary sanctions, and had a project a few years ago where we were talking to judges at felony level cases. They just weren't on the radar of prosecuting attorneys or judges that is a major consideration in sentencing. And so that was very informative knowledge. Just doing enough interviews, you hit a point of saturation where you're like, okay, I'm hearing how things are prioritized, and we can move ahead on the basis of some of that knowledge.
Any other comments or feedback for the U of M team?
Correcting Professor Eugen, perhaps, helpful.
Sorry, sure. Is there anything else you need from us, or do you feel like you got what you needed today?
I feel like we have. I just want to thank the commission for each of these discussions. I think we get a little farther down the road, and as I said, I mean, I've spoken highly of your staff, but they've been absolutely terrific to work with. So I'm optimistic about our ability to provide some useful information to the commission.
All right, well, thank you very much for coming in today. It was a great discussion. Oh, I think you have to open that back up and unshare your screen unless you can.
I think they can just take over. So,
Someone else can take over?
you gotta do it.
Okay.
I'll do that.
I have this gray mark on my screen.
Yeah. So, wait a second.
All right, now I'm gonna move to, what are we at? Oh, we're at the sentencing guidelines in operation. I'm gonna say to folks, I asked for this. We've been talking so theoretical for a while that I thought that we should start to actually get into using the guidelines here at the commission, and just, you know, this I hope will be one of multiple times that we engage directly with the guidelines while we're here. I'll let you guys introduce it, but that the goal is to actually, you know, have some experience in working with this information.
Thank you, Madam Chair. And so what we're going to do here is an exercise. It's almost a continuation of what we started when we did the orientation for new commission members and kind of describing how the sentencing guidelines work. But this is going to be a little more specific, where we're going to take two cases and walk through how the guidelines interact with these actual cases. And we're going to anonymize the cases, but they're real cases. And we hope it's going to accomplish a couple of things. One is, well, maybe three things. One is to illustrate how the guidelines work in a typical non-presumptive commit case and a typical presumptive commit case. And so therefore be instructive about how the guidelines work as we sort of begin. And I don't know how much longer we can say we're beginning, but I think we're still in the beginning stages of the comprehensive review. The second thing we hope it does is sort of give you a taste for a typical case and what a typical case kind of feels like. And the third thing I hope it does is give you an illustration of how we can use this kind of tool in the future. So right now we're not trying to illustrate any particular guidelines policy, although you'll see some guidelines policies popping up, and it'll be guidelines in action, but that's not the intent here. It's just to illustrate typical cases. But say in the future you want to talk about Hernandizing, for example, we could have a case that illustrates the impact of Hernandizing on a particular sentence. So this is a tool that we can use in the future. So that's the purpose of what we're doing. And Leah Bauer will start us off introducing us to John Doe.
Yes, so as Nate said, this is an activity we're trying out. What I'm going to do is I'm going to kind of tell the story of what happened, and then Linda is going to walk us through how a sentencing worksheet would be filled out based on the case that I'm talking about. And as Nate said too, this is an example. It is a real example. We've just taken out the identifiable information, and it is a typical case that we have in our data set. And it's pretty straightforward to start off with. So this is case number 1 of John Doe. So John Doe is a white male who was 23 years old at the time of the offense. And what happened was on August 5th, 2021, law enforcement was dispatched to a report of a shoplifter in St. Louis County. The dispatch reported the male suspect was giving loss prevention a hard time. A sergeant arrived on scene and observed 2 males that appeared to be arguing in the parking lot. The sergeant recognized one male to be loss prevention, identified as Keith, and the second male was later identified as John Doe. The sergeant exited the squad and John started walking away. Keith identified John Doe as being involved and told the sergeant that John had assaulted him. The sergeant detained John. An officer then arrived on scene and placed John under arrest. In John Short's pocket, the officer located a plastic bag containing a white crystalline substance that later field tested positive for the presence of methamphetamine. And he also found a bag containing 3 Klonopin pills, and in his sweatshirt, law enforcement located a Xanax pill. Keith provided a statement to law enforcement. He had observed John selecting various items throughout the store and concealing them in his backpack. John then passed all points of sale and exited the store. Keith confronted John outside and asked him to come back inside to discuss the unpaid merchandise he had concealed in his backpack. John was non-compliant and he began to walk away. Keith grabbed John's wrist and informed him that he was being detained. John pushed Keith and a brief struggle ensued, during which Keith took possession of the backpack. John dropped his cell phone, which Keith retrieved. John then approached Keith aggressively with his fists up. Keith instructed John to step away from him, and John complied. Law enforcement arrived shortly thereafter. In John's backpack and sweatshirt were 15 unpaid for items, valued at a total of $59.43. John was charged with the following 3 offenses. Count 1, a felony possession of a controlled substance in the 5th degree, methamphetamine. Count 2, a misdemeanor assault in the 5th degree. And count 3, misdemeanor theft, take, use, transfer of movable property, no consent. So that is the story. I'm going to hand it over to Linda.
Thanks, Leah. John's worksheet, which is on the screen, was completed for the felony offense of controlled substance 5th degree, which is ranked at a severity level D2 from the drug offender grid, one of 3 grids used by practitioners. The worksheet also includes 2 prior offenses in criminal history and a custody point. There are 4 components which make up a criminal history score. Custody related to an eligible offense that they are under supervision for when the current offense occurs, and any eligible juvenile, misdemeanor or gross misdemeanor or felony offenses which have received a sentence prior to sentencing on the current offense. For the custody status point, a defendant can receive either a full custody point or a 1/2 point, depending on the offense that custody is assigned for. When assigned for a misdemeanor, gross misdemeanor, or severity level 1 or 2 from the standard grid, or D1 or D2 from the drug offender grid, the value is 1/2 point. John is under custody for the gross misdemeanor DWI task refusal, so he has been assigned 1/2 point. Although John does not have any juvenile priors in his criminal history, adjudications of delinquency for felonies would have been included under the policy that permits juvenile felony priors, to be included if the defendant is under the age of 25 when the current offense occurred. Since John was 23 at the time, they would have been eligible to be included. They weren't because he didn't have any according to the worksheet. The defendant has a prior gross misdemeanor offense, the DWI task refusal, which has been assigned 1 unit in gross misdemeanor history. Offenses eligible to be included here must be targeted misdemeanors from statute, non-traffic gross misdemeanors, gross misdemeanor DWI or reckless driving, or felony offenses sentenced to less than a felony duration. The standard policy is that these priors are assigned 1 unit each, with 4 units combining to make 1 misdemeanor gross misdemeanor point, generally the maximum points assigned for these priors. There is a felony prior, firearm, serial number, received, possessed with altered number. This offense is ranked at a severity level 1 and is assigned 1/2 point in criminal history. Under felony policies, any felony half points are rounded down before adding in any other criminal history. In late 2021, the commission that was seated at that time was made aware of an error in the calculation of criminal history when there was a 1/2 custody point assigned. It was determined that the worksheet system used by probation was adding any half points for felonies with the 1/2 custody point. In January of 2022, the commission released interim guidance to address the issue, which was later affirmed in State v. Bogdanovich. Since there is no policy on rounding the custody point down, nor any half point reflected on the sentencing grids, it was determined that the 1/2 custody point would not be included as part of final total criminal history calculation. As you can see on John's worksheet, with the rounding down of the felony point and the removal of the custody point, his total criminal history points are 0. Under the guidelines, a severity level D2 with 0 criminal history carries a disposition of prison for 12 months and 1 day. However, that disposition is stayed under the grid. When John was sentenced in May of 2022, he received a sentence of 12 months and 1 day and was placed on probation for 3 years, receiving jail time, fines, and other conditions of probation.
Do you happen to know how much jail time this person got?
I apologize, I did not look that up, but one would conclude in 2022, it would not have been more than 365 days.
You should have thought of that earlier. I didn't think to ask that question.
That is speaks to the jail credit question that came up.
Yeah, right. So any questions or I just asked a question. Anyone else have a question before we?
Madam Chair, I've got a question.
Commissioner Knudsen.
What's the update or of the criminal history score? I mean, is it instantaneous when something gets filed in Mensis? Is there a delay of any kind? How accurate is the score?
You guys have an answer for that?
I would say the accuracy of the score is up to the probation agent, since they are the ones looking up, and the process would be to first determine what is eligible criminal history under the policies, and then define the one, if there is custody, which aligns with the current offense date. So that would be what we would presume would be the accuracy of that point.
Okay, so the Sentencing Guidelines Commission is totally relying on probation's review of all prior records and determining the history, the criminal history score? Who determines the criminal history score?
Commissioner Knudsen, what happens is probation will submit the worksheet to the Sentencing Guidelines Commission through the electronic worksheet system. And that worksheet is then reviewed for accuracy under the policies of the guidelines. So we can't go in and investigate every single prior that they included. But let's say, for example, if John's worksheet had the offense date of August 5th of 2021, and all of his priors had expiration dates of 2020, but they had assigned a custody point, we would seek out why that custody point was assigned. If there does not appear to be a prior in criminal history that matches that. But again, we are only able to look at it under the policy. Was the point assigned correctly? Is it an eligible prior to be included?
But you've got those records, right? You can.
Can I ask a question though? Because I thought, and I could be misremembering, I thought we had an integration with Mensis to the electronic worksheet system that pulled the history.
That's correct. So the way that it works is the probation agent will seek the information related to the defendant and the offense they have been convicted of from MGA to auto-populate that information into criminal history, into the worksheet. And then what they will do, if there is one available, is search for whether or not there has been another worksheet completed and is in the system. And from that, they are able to transfer those priors from that worksheet onto their current worksheet with the huge caveat that that is to save them keystrokes only, and that they must then go in and verify every prior that's on there. But we do, in the interest of time and the number of these worksheets that are delivered to MSGC annually, we must, I believe it is appropriate that we are only looking at the policy impact to the worksheet, as opposed to whether or not the probation agent got everything right from the records that they have, because there are other parties in the courtroom that are looking at that information and would raise question if there was something to be addressed about the worksheet that they didn't feel was appropriate.
Okay, Madam Chair, I'm not asking my question very well, but this was very helpful, all the rest of the discussion. So I sentence somebody today, convict them of a felony, and they're picking up a point, right?
They're picking up a point value related to the severity level of the offense they were convicted of for any future criminal history.
Right. So my question is, I do it today, it gets filed in Mensis, somebody else is sentencing them tomorrow. When does this get picked up? How fast, what's the turnaround? And so you have connectivity to MGA or to Mensis, and so that's in your system immediately. So tomorrow, when a probation officer does an investigation for a different case in a different county, do they have that current criminal history score? Or what is the delay in obtaining the updated information?
Commissioner Knutson, I can't speak to how quickly information is placed in MGA, but it would only be one of the tools available to the probation agent to investigate someone's prior record. Our current, Jill, correct me if I'm wrong, our current integration with MGA is simply to allow the probation agent to pull in the data related to the defendant along with the current offense. So that ensures that we receive sentencing data on the worksheet that's going to later align with the sentencing data in the system. And so everything lines up. We have the right birth date, we have the right name, we have the right conviction plea date, and hopefully the correct offense and count number. Everything where that Nate is showing that worksheet on the system up above that, that's what we can pull in from MGA. But when you scroll down and you go below, that's everything that the probation agent must either copy the priors from an old worksheet and re-verify or manually enter themselves. So if something happened today and something is happening tomorrow, we would ask the probation agent to ensure that they have completed an accurate picture of that criminal history. and can only assume that it is and check it based on the policies.
So Commissioner Reeves, would you mind filling us in on
Thank
what
you.
you do?
Thank you. So how we do it in Hennepin, I'll speak for Hennepin, is when someone comes in, a new felony case comes in, we have a CRS agent or someone working on the criminal record summary who will complete the summary and put it in the system. That's provided to the court. So that happens pretty quickly. After they get the complaint, they go through pretrial, the criminal record summary is in the computer almost very quickly. Throughout the course of the case, as it's going through the court system, we're already looking at it and saying, oh, this person could potentially get 12 months in a day or whatever the sentence may be. Once we do the guidelines worksheet, we pull up the criminal record summary, which is already all the offenses that, whether they decayed, all that. I'm looking at one now. If they're decayed, all the information is on here. So I check my guidelines against the criminal record summary that's already been completed. They pull all the records from all the systems. It's all on here. They check it. It's got the severity level. Everything is already on there. So then if I'm doing a PSI, for example, I may start my guidelines worksheet already and then hold it in the system until they're sentenced. In the case that he said about a case coming in the next day or shortly thereafter, I already got mine on hold in the system. So any agent coming in behind me is going to see I have a guidelines worksheet on hold. Whatever they decide to do with that, I can't tell you, but they can see that mine's on hold. For the most part, that's how we do it in Hennepin. If for some reason, because we have a whole unit that does the criminal record summary, they do the PSI, they're doing all these things simultaneously on different parts. Smaller counties may do it differently, but we have the information system. So I'm always going to the criminal record summary and looking to see, did I forget a case? That what they have on their sheet is the same that's pulled from the guidelines worksheet that's already sitting in the computer from a previous agent from somewhere else, that I can just pull that information into my new guidelines worksheet, which makes it easier. I'm grateful for that. But I do have to go into every single one and edit it to make sure that it's correct, or it won't let me advance in the system. So there is some checks and balances, and oftentimes their guidelines is very receptive about, you forgot this, or why did you assign the custody point here, or you forgot to put this comment here. It can be very back and forth. But for the checks and balances part, but we already have the information. So this client I'm looking at doesn't have a guidelines worksheet done already, but I can see essentially what it's going to say because the criminal record summary has already been completed for me. So that's kind of how we start. They've done all the background checks and did the countrywide search, put everything on here, manually entered it in if they had to, et cetera. And then I can put that information if it doesn't pull over onto the guidelines worksheet. I don't know if that helps, but it makes it easier for us.
I want to move on to Commissioner Ladd has been waiting for quite a long time, so I'd like to let Commissioner Ladd ask her question or comment. Thank you so much, Commissioner.
Thank you, Madam Chair, and I apologize for having my prosecutor hat on right now, and perhaps this isn't even germane to this conversation, but I don't quite understand why this disposition, as I understood sort of the case scenario that was laid out, why it wasn't a 15218 disposition, because based on the worksheet, there isn't a prior, and so this person would be eligible even over the prosecutor's objection, unlike a typical stay of adjudication, which the court can't grant over prosecutor's objection. So I'm curious why this didn't trigger a 15218 disposition.
Commissioner Ladd, that would be outside of our purview. That would be up to the members of the court to argue for the prosecution and the defense. We're simply looking for whether or not there has been an imposed sentence or a stay of imposition related to this offense.
So this is a good example. And again, I think this goes back to our comprehensive review. I would tell you as a matter of policy, this isn't anything we even get to debate or argue. These are automatically happening. And so when we talk about dispositions of cases, 15218s are basically given. If there's not a prior and they're eligible to get it, it's automatic. That statutory sentence is automatic. And I think that's, again, important because as we're talking about consequences and how consequences are happening with certain kind of cases, and you're talking about a felony 5th degree offense case that otherwise is eligible for that, I think across the state, again, looking at why that's happening and not happening as a matter of course would be an interesting data point.
Linda, if Mr. Doe had had a prior 15218, which is a stay of adjudication, then to Commissioner Ladd's point, he wouldn't be eligible for a second one. Would a prior 15218 show up on a sentencing worksheet?
No, in order to receive criminal history from an offense, there has to be an imposed sentence. So there has to be a stay of execution or a commit to prison, or they received a stay of imposition. So any other non-conviction, which is a term that I use for training, any non-conviction disposition, like a 15218, a continuance for dismissal, those are not present in criminal history. So if he had potentially a prior stay of adjudication, we would not know that because it was not revoked prior to this offense being sentenced. So we don't know if it's out there or not. So those are definitely courtroom kinds of decisions, not guidelines decisions.
So
Charging.
I'm speculating, Commissioner Ladd, but that could be the answer to your question, is this might be the second bite at the apple.
That's a good point. It's the.
Thank you.
What we're seeing on there are offenses included in criminal history score, but not offenses that would be in prison, right? Right, okay, that's a good point. Commissioner Price?
Thank you, Madam Chair. Maybe I missed it, but we were told there were 2 other counts, and apparently he pled guilty and they were dismissed rather than convicted, even though they would be misdemeanor counts. I think the judge handling the felony conviction could sentence the misdemeanor charges if they weren't dropped. I guess really what I'm getting at is that it's sort of related to the previous exchange, where there are things that are not on these forms that are important, not only to the people in court for that case, but if those 2 counts had not been dropped, if I'm right about that, then they would potentially add to future criminal history, but apparently they were dropped.
If I may, actually, I believe he had a misdemeanor theft. So I'll just speak directly to that. That is not a targeted misdemeanor. So even if it had received an imposed sentence, it would be ineligible to include because it is not part of the 7 targeted misdemeanors that are allowed.
How about the assault 5?
The assault 5th degree would be. But again, it would not have given him a point. It would have given him another unit on the worksheet, but he would still be too short of the full point of the 4 needed for the full.
But in a future sentencing, it could put him over the line to give him a misdemeanor point.
If he had 2 more added to it in the interim, yes.
Okay. I'm trying to think time-wise, if we should do the next one or hold it until next time, because I think we need to do the item number 7 as well, take that direction for this meeting.
You know, it might be prudent to move on. I mean, we might finish a few minutes before 3:30 if we move on, but we might not make it by 3:30 if we continue.
That's what I was thinking. Let's save the second one, because I want to keep doing this in different ways. And so, I mean, I actually think this was really interesting today, and it brought up a lot of really interesting issues in ways that makes it tangible. Does the commission, maybe I shouldn't make an assumption. What does the commission think about going through some cases in this way from time to time?
Skillful.
Okay.
Reiteration.
So we'll keep thinking about, doing it, but let's save the second one for a future meeting. And thank you so much for coming today and putting that together. I really appreciate it. But we need some direction to what we're doing next time. So we got to get to number 7, which is next steps in the comprehensive review for Nate to take over discussion.
Thank you, Madam Chair. And before I begin this, I'd just like to kind of acknowledge the nonstop ticking of the clock and just sort of look at where we are in sort of the big picture. So there are 4 dates that I have on my calendar. June 30th of 2025 is when funding for phase 1, which we're currently in, runs out. So that means that our contract with MAD, which is doing the public engagement, that ends on June 30th of 2025. So unless we get funding for a phase 2, which isn't a given, given the current budget situation. I mean, the current budget situation is actually, it looks pretty good for some funding, like one-time funding, which this would be one-time funding in phase 2 for the next biennium. But ongoing programs may be looked at with a more skeptical view, because there's basically money now, but structurally there's an imbalance in the budget. So that means on July 1st of 2025, which is my next date, the day after, that's when the phase 2 begins, which is currently unfunded, but that doesn't mean we have to stop it just because it's unfunded. We can continue with existing resources. It just might slow down. The next big date for me is December 31st of 2025, which is when Arnold Ventures University of Minnesota research grant expires. So that's when we finally say goodbye to the panel of experts that's sitting at the table. We accepted, and we get to keep her. And then the next big date I have is January 2027. I know that seems like a long time from now, but it's closer than you think. And that is possibly a new Sentencing Guidelines Commission. We don't know, but that's when the next administration would take over. So if this commission wants to do something and wants to know that they've done it, it would have to happen by January 2027. So just kind of some dates to keep in mind. So you have in your meeting materials an old document, which was my attempt back last fall to look at how the comprehensive review might occur. And we talked about different blocks that we might address and sort of this interplay between the research team and us. And at that point, I didn't really realize that the limited timeline that we had the Arnold Ventures people. So I've since sort of reframed how we interact with, in my mind at least, how we interact with the research people. I think we use them hard while we've got them, and we can unwrap everything at our leisure later on, but we need to get as much research out of them as we can while we've got them. And I think we have a good handle on how that's going. But that still leaves us to the commission's blocks. And the first block that I had in mind was purposes and principles. So if you looked at the sentencing guidelines and you opened it up, it says Minnesota Sentencing Guidelines and Commentary, and then it says 1. And 1A is purposes and principles. And it's really a lot of language that we can unpack in detail and kind of talk about the history and why the commission put those particular words in there. And many of those words have not changed, as we'll see, since 1979 or 1980 when the commission drafted the first sentencing guidelines in the nation. But we can explore those purposes and principles to some extent. I think it will be it will echo some of the discussions that the commission's recently had in looking at the objectives for this comprehensive review and some of the principles that should guide the commission in its comprehensive review. There's obviously going to be a lot of overlap between those concepts and the purposes and principles of the sentencing guidelines themselves. But what I would propose, Madam Chair, is beginning that sort of with a Minnesota-focused, historical-focused look at the next meeting, with possibly broadening that out at future meetings, looking at other sources. We've already been introduced, for example, to Professor Reitz's work on the model penal code sentencing and some of the purposes and principles. There would be a good start, maybe looking at other states and their purposes and principles. But seeing if we can get some work done on purposes and principles while the researchers are doing their thing, while MAD is doing their thing, which isn't to say that purposes and principles shouldn't be informed by research and shouldn't be informed by data. I think the idea is it just seems like an area that we could start, or you could start without a whole lot of research and data, and then modify that as the research and data comes in. So that would be my proposal to sort of kick off in the April meeting, Madam Chair.
Comments from the commission? No. Guys are making this way too easy today. does that sound like a good direction? Do you want to, I think the point is, we've done all the setup to launch some of the other pieces. So now it's like, what do we want to do? Where do we want to start while some of that work is going on? And that feels, like you said, like the one area where we don't immediately need research, other than Professor Wrights probably has some good overviews of what other states have done, the model penal code's view of purposes and principles that he could share with us, and things like that. Commissioner Larkin.
Yeah, I think what I'm hearing is we should get to work doing something while they're collecting the data. And maybe another category we could look at is, are there just sort of like legal glitches within the guidelines that don't necessarily have to do with the length of sentence, but just from practitioners' perspective, are there glitches that we could fix? And I don't know if there are any, but I mean, I'm imagining there are some problems that maybe aren't related to data collection. They're just legal and need quick fixes. Anything of that nature? I don't know, because I just had a case where it's like, oh, this is a problem we're going to need to address. It has nothing to do with research or anything else. It's just something like, oh, the guidelines miss this and maybe needs to address this to be consistent with the statute, that sort of thing.
Well, we do from time to time bring to the commission's attention, technical issues with the guidelines. I mean, we heard a little bit about the half custody status point, and members of the commission who've been around for a while know that that's an issue that has occupied a lot of bandwidth for the commission for a number of years, and somewhat too frustrating result where we really didn't get a solution done. We're just sort of, we have this vestigial half custody status point that isn't really doing anything. And I didn't mean that in a disrespectful way. I'm just kind of observing that a lot of time was spent, and unfortunately we weren't able to come to a consensus on that. So we could attempt to address some of those things. Some of those things may get sort of swept up in a larger wave of change if the commission's interested in making broader changes to the sentencing guidelines too. So I don't know, if we need to spend a lot of time figuring out how the sale is set if we're going to transfer over to a motorhome, for instance. So I don't know. I guess it's up to the commission if they want to.
And to be clear, I wasn't talking about that issue. I was talking about something we may have missed on the permissive consecutive sentencing list. So just things like that.
If Madam Vice Chair, if you wouldn't mind bringing that to staff's attention, we should bring that up. So I don't know that we have anything like that in our pipeline right now, but this is the time of the year when we typically will bring those things up to the commission's attention.
Yeah, and just for the benefit of the full commission, because not everybody has been on the commission through a cycle, we probably have like a month or two here where we can do some thought work, and then the legislature will end. And I do happen to know there's at least a couple of new crimes that have been proposed. So then we have to shift to dealing with any changes that came out of the legislative session, ranking those crimes. If we have to change anything else in the guidelines, we'll change them, which would be a good time to do this fix. And then having our public hearing on that process and all that. So there's going to be a little interruption there where we do have to shift gears and make sure that we address that annual work too. Commissioner Frace?
Thank you, Madam Chair. I guess maybe I tuned out for a second. I'm not quite sure what question is being addressed to the commissioners right now, but let me suggest a question and see where it goes. As I read this sort of timeline and the sort of staging of how we identify research questions ahead of time, it seems like now we should be, and I assume those are research questions both for staff and for the Rabina people, or them working together. So it seems that we should be identifying research questions both under the Block A and Block B, because Block A is supposed to be happening now, and Block B is the next one, and we should be identifying research questions for that. And I don't know what process to use other than, people raising their hands and saying, well, here's what I think about a research question in that block. I don't know how to think about the process.
Well, it's actually, you didn't put it up, and maybe because you don't want us to look at it anymore, and probably you should, because that was our original, that was actually Nate's brilliance to try to come up with a way to structure how we move forward, but it's not going to work that way now.
Okay.
And the reason for that is we know what MAD needs to do, right? And we know their timeline. And we know that the U of M team is going to need a much longer timeline. So our discussion with them today was, what is the question that we'd want them to answer? And that was the point. That was the point of our trying to hone in on what are they going to do research while we have them. And then so then the structure doesn't quite work the way that Nate originally envisioned it. If you want to talk a little bit more about that.
Yeah, I think this is, and although it does, have us getting done in fairly short order, the problem with this design, so you're right, as envisioned right now, we'd be looking at the Block B defendants past, and we'd really be doing that before we get into purposes and principles. And we'd be looking at what are some aspects of criminal history score and the defendants past and those sort of things that we would like the research team to look at while we're working on Block A. I think that whatever merit that may have had, it's a little too stately for the timeline that we have here. We only have, we had the 2 years, and now we have, 22 months or 21 months. So the clock continues to tick, and I think I don't know that we have the luxury of doing it this way.
So I think I always use this analogy, and people are going to start laughing at me someday. We're building the plane as we're flying it. Yeah, we are. And so at this point, one thing we do know is that we don't need the assistance of either of, except for Professor Wrights, we don't need the assistance of MAD or the empirical research team to look at purposes and principles. So we could start that work. Then I think, we'll get down the road a little bit more, and we'll start to get feedback from our engagement about what issues rise to the top. And then I think we could actually start to look at some of those issues in advance of the data coming in and start to think through policy-wise, maybe even have some back and forth with the research team on, is there any research or information that they could give us that would be helpful to us. But I think that I don't quite know. I don't think any of us quite know, how are we going to do that? But that's probably how it will unfold. But so we're just kind of at the stage where we think we could do purposes and principles now, and then we kind of have to see where everything's at to see what we could do next. Commissioner Larkin.
That feeds into what I was thinking, which is, okay, so Jeff Shorba said, I'll send this out to all the judges. Just give me the questions. I want to see them first. So I assume we're going to have the questions we kind of have. Is that it? So if we get that out to judges, we'll probably start to get some feedback where judges might point out some things like, well, here are the things you should fix with the guidelines that really don't have a whole lot to do with policy so much. I know everything has to do with policy, but they might have just more technical concrete things that we could talk about. So that's what I was suggesting. Maybe some things will come to us.
Yeah.
And that's probably where they'll come from, right? Because those are the people or the lawyers saying, it's a problem, could you change this? And maybe it's not going to, really change the impact of sentences as opposed to just the process we use to make it easier for people to use the guidelines.
Yeah.
So maybe we could do some of that as we hear about it.
Yeah. Commissioner Fraisse? Yeah, go ahead.
Thank you, Madam Chair. Well, just following up on what you said, Madam Chair, about what we can and cannot do to identify issues. I mean, on this Block B, the criminal history in particular part of that, I assume maybe this is already in process and is well understood, there has been, in previous presentations from staff, and I think from Rabina, there has been a number of observations related to criminal history, in particular, the rising scores over time, to which I would add, the rising proportion of convicted felons who fall into the zone on the grid or the grids where you're recommended for prison because of your criminal history, not because of the severity of the current offense, not because of a mandatory or a special rule. You're pushed across the grid at low and medium severity into the presumptive prison area. And I just looked at this morning. In 1978, the baseline year that this commission based its initial policies on, only 5% of convicted felons were in that zone. Now, I think, looking this morning, the most recent data here is still 2021, almost a quarter of the convicted offenders, if you add up all three grids, are in that zone. And so this is rising criminal history, I guess. And it sounds like the Rabina people and staff have sort of already teed this up. What can we say about the causes of that, or the components, different causes of that, and how should we think about that as a commission, as a policymaker? Recognizing that the original commission didn't expect so many people to fall in that zone, and therefore didn't expect prison populations to be as heavily populated with people from that zone. Now, maybe it's a good thing, but nevertheless, so this is not a policy change that was made. It's in spite of the down weighting of low-level severity cases. It's something that happened from practice, and perhaps to some extent from criminal behavior. But anyway, so I guess I just wanted to throw that out there as something that maybe is already in process and is well understood, but it's what I think is identifying an issue in that block.
So can I to go back to our presentation that Professor Eugen walked us through, if we got to a year and a half from now and we didn't understand that, is that your drop dead thing? Like you want to be able to understand that issue?
And I think we have already. I think we've already agreed that we want to understand that issue and talk about it.
So I'm gonna hope that they'll add that to their list over there. Okay, good. Commissioner Larkin.
And I want to understand that issue as well, and that's why I brought up this notion of, do we know, based on, a snapshot of the prison population at a given time, how many of those people are there because they fall into that group of people, like they've never really committed one offense that you would send somebody to prison for, but they just keep offending. So I'm interested in that as well, but I want to make sure, you go, well, 25 people fall in there. Well, how many people are really ending up in prison as a result of that circumstances, as opposed to, as Commissioner Ladd has often referenced, the installment plan.
Good point. Other questions, input, like, does this help? I mean, like I said, we're building the plane as we fly it, so I really apologize if it's not, the path is not always clear, but I think we're revealing it as we go. And I hope that that's making sense as we hit each step. So purposes and principles for next time as a place to start. I think I assume we might hear from the U of M on if they refine their ideas after the input today. Anything else to talk about on this one? You guys are too quiet. I told you. Yeah, full of things. Okay, all right. So I think we have some direction for next time. I have to look at where the agenda is, where we are. That takes us to number 8, Executive Director's Report.
Thank you, Madam Chair. I have 3 things to report, but before I do that, I just want to say any attendees who are interested in speaking after my report, please raise your hands. It looks like you're all joining the meeting by computer, so you should be able to press the little hand icon. It's on the bottom of my screen. I don't know where it is on yours, but if you're able to raise your hand. And I'd ask Katie online if you could just raise your hand and test that that's working. All right, thank you, Katie. So the first thing I'd like to report it's actually related somewhat to that John Doe worksheet that we went to, and the reviewed line on there that says that the worksheet was reviewed by MSGC. And the idea is that, and Hennepin County may do things a little differently, but the idea is that the judge should have a reviewed worksheet at the time of sentencing, so that the judge has the confidence of knowing that an MSGC staff member has done a facial review of that worksheet to, again, not doing independent research, but just saying, does the worksheet make sense? Does it comport with guidelines policy? And, to some extent, hopefully that's done by the electronic worksheet system automatically, but we do find that it catches some errors to have MSGC staff review that. Now, years ago, and then those would be part of our records, and we take those worksheets and put them into our data set. And years ago, that's where our data set ended. And then we started getting information from the courts. And we found that there were sentences that were occurring that we did not know about. We did not have worksheets to review in advance. So these would be missing worksheets. But we want to know how the guidelines policy interplayed with those. I mean, whether there's a worksheet or not, if the sentence is a departure from the guidelines policy, it's a departure from the guidelines policy. So we would ask for worksheets after the fact for missing worksheets and attempt to get those from probation officers. Sometimes, despite our best efforts, we would not get those missing worksheets. And in those cases, MSGC staff would make them up. We've been reevaluating that practice recently. The problem with making it up is, as we've sort of gotten into already, today we don't necessarily have all the same facts that the probation officer has. And in some cases, we'd be sort of trying to make the worksheet sort of fit the sentence. And it's really polluting the quality of our data to include in, as if it were a legitimate worksheet, a made-up worksheet by MSGC staff. So we've decided to take a different tack. And what we're rolling out going forward, and if this is something the commission would like to be more fully briefed on in the future, we could do this. But what we're trying to do right now going forward is just telling the probation officer, look, this worksheet is missing. It needed to have been done. It needs to be done. Please do it. And if they don't do it, we will just record that as a missing worksheet, which is a new type of data for us. Because as I said, we didn't used to know that these were missing worksheets because we didn't get the data from the courts of these sentences. So that's a practice that we're beginning now is we won't be making up missing worksheets anymore. We are going to rely on probation officers to create the worksheets as they're required to do under the way the system is designed. The second thing on my report has to do with.
Do you want to ask if there's any questions?
Yeah, any questions about missing worksheets? Is it something you would like to be briefed on more fully?
Definitely.
You would?
Yes.
Okay.
And it's appropriate. I mean, I don't know how other counties do it, but if we get a list from our supervisor, a naughty list. You must do these guidelines worksheet, and we can follow up with you to make sure it's done. And you've got to send a confirmation that you did it as it should be, right? So I definitely would like to know more information about that. And I think it's appropriate that it's marked as not completed or missing guidelines as opposed to just doing it, because if that's the case, it goes in the system. The next agent who's looking at it sees that it's basing information off of that.
Right.
And if that information is missing, then ours potentially could be wrong down the line. A subsequent one, which has happened in Hennepin County, where someone was not supposed to go to prison, but did because it was a faulty guideline, and they caught it, and the probation officer was horrified, right? But it could potentially happen, so I would love that.
And I would say a related subject, this is kind of the bane of my existence, is what's euphemistically called an inadvertent departure, which is where a judge sentenced contrary to guidelines policy without knowing that the judge was sentencing contrary to guidelines policy, which is a little bit horrifying to me, that somebody who's basically mis-sentenced And it's not to say judges have to follow the sentencing guidelines, but judges are required to know what the sentencing guidelines recommend before making their determination. So I shudder every time I hear the phrase inadvertent departure. So that's number one. I'm going to turn number two.
Just real
Yes.
quick,
Yes.
I'm going to say this publicly because I would like to connect after this meeting because we should also go to the organizations where the directors are and tell them about this and ask them for their help in making sure that worksheets are completed. And I can help facilitate that. So
Awesome.
let's do that.
All right. All right, second item, I'm going to turn it over to Research Supervisor Leah Bauer for some good news.
Yes, good news. This will be quick, but we have finally hired 3 new research staff. This has been a long process. 3, yes. So 2 of them, Devontae and Matthew, are starting next week. And so hopefully you all get to meet them at the April commission meeting. And then the third, Andrew, I have to get all the names right here, is starting in May 15th. He's moving from Alaska, so he has a little bit of a move to deal with before he can start with us. But I'm really excited. The agency's been understaffed for quite a while, and to get 3 new faces with all the skills will be really exciting. So look forward to bringing them to the commission meeting, so you all can meet them.
And one caveat to that is Andrew is temporary.
Matthew,
I'm sorry. Matthew is temporary. Sorry, if Andrew, if you're listening. Matthew is temporary and is his funding for his position comes out of the funding for the comprehensive review. So he is really dedicated to the comprehensive review. I really hope he can integrate well with the University of Minnesota research team, sort of be the bridge between those two and really help move the research project. But also, dedicated to any, like if the commission has like a descriptive statistics report that they want done or something like that, I think Matthew would be the person for that too. So we're really, really excited to have these new folks coming on board. I do foresee requesting of the next legislature funding for phase 2 of the sentencing guidelines, commission's comprehensive review of the sentencing guidelines. And in such a request, I would be requesting to continue Matthew's position. So for another 2 years. So that's number 2. Yes.
I'm just going to say yay.
Yay, I know. I know. So the other 2 positions have been vacant for a long time. They're not the same positions, but basically Ann Wall, you may recall, retired last summer. And then we had another research analyst who has been gone over a year. So we've had that empty chair for over a year. So we've had like a cumulative 1.5 years of empty chairs. So we're really looking forward to getting these folks trained in. So the final part of my report is a legislative update. We've had about a dozen unique fiscal notes plus different versions of them and so forth. So we've definitely had our hands full with those. And as the chair alluded to, at least some of those will be things that they'll undoubtedly pass into law, and you'll have to change the sentencing guidelines to conform to them in the future. I just want to talk about a couple of them. One has to do with predatory offender registration reform. One of the issues that the predatory offender registration statutory framework working group recommended was really improving the data. So there's a lot that's not known about the pool of predatory offender registrants and that sort of thing, because it's not how the system was designed. It wasn't designed as a data system. It was designed as a registry and it wasn't designed to query and so forth. So they're really looking for the BCA on their side to develop a better data infrastructure. And then they're looking for the humble Minnesota Sentencing Guidelines Commission to do a lot of analysis with that data. And generally to find out whether the system is working as a police investigative tool. So that's something that we anticipate would really require an expansion of the agency, to be quite frank. So that particular provision, the data provision, has been cut out of the bill for this year, but this morning, when doing that, Chair Moeller said that it was her intent to reintroduce it next year. It's strictly a money thing. It's not that there's no longer will to do that. So that is something that could be an agency mission in the future. Oops, we're running up on time. The other thing I wanted to talk about was an interesting bill adding, and this is the biggest prison bed impact, is adding to the list of crimes that permanently disqualify you from ever possessing a firearm or ammunition, adding violations of protective orders, felony violations of protective orders, currently not on the list. And we are struggling with our fiscal note on that. We are now on version 3. Just some logical errors, I think, on version 2. So we're looking at that. And if we ever do get a final version on the fiscal note, that probably will be a significant enough impact to require a demographic impact statement, but I don't think we can do a demographic impact statement on the policy because although there will be new prison beds, I don't think we really know the demographics of those prison beds. Having said that, I think we can provide the legislature with some information regarding the demographic characteristics of the people who commit protective order violations, which will probably have some correspondence to those prison beds, but won't be specific enough that we can say this is what the occupants of the prison beds will be like demographically. Madam Chair, that concludes my report unless there are any questions.
Any questions for Nate? All right, not seeing any, then we can move on to public input.
All right, members of the public, as I previously stated, at this time you have an opportunity to let the commission know if there's anything you'd like them to know, but you have to raise your hand. So please raise your hand and I will unmute you. Madam Chair, no one is raising their hand.
All right. Well, then I think that brings us to the end of our agenda. Any other business? Hearing none, unless there is an objection, I'm adjourning the meeting and we will see you all in April. Thank you. Thank you.
Thank you.